And good morning. Yes, it is a good morning despite circumstances. Today's title is 2012, When Courts and Police Break the Law. The fact that PNC Bank and its attorney chose to proceed with the foreclosure sale in light of the Affidavit of Negative Averment filed with the court was shocking. What they called an auction was a charade. I was there. My home was sold without due process of law. In fact, the court broke many laws in this saga of a lawsuit that has never gone to trial. Now, they will likely order the police to break their oath of office and uphold the criminal actions they have taken. What can we do when courts and police break the law? Yes, for those of you that are on Facebook, and I don't know, hundreds of people responded when I posted a message on Facebook indicating that I had just returned from the court, and yes, indeed, they had sold my house, and well, let me just explain that proceeding, first of all. I got to the court approximately 12 minutes before it was due to start. The parking lot was absolutely packed. I spent close to 10 minutes at least driving around looking for a place to park, and I ended up parking as far away from the building that I had to go to as was possible. I mean, it was across the street and in a huge parking lot, and I was 2/3 of the way to the end of that parking lot, which is how much it was filled up. By the time I got to the room where the thing was being held, it was already in progress, and the lady was giving some instructions on what to do with credit card purchases or something. And I found a chair, 4 seats in on the second row. There were only 2 empty chairs in the entire courtroom. And it was called the Brevard Room at the Titusville Courthouse. Anyway, I sat in the chair closest to the door and easiest to find. And I wasn't in my chair a minute, I don't believe, or so, when they called my case. My case was the top of the list, and a man sitting 4 seats over to my left, 3 seats over to my left, in the front row, he bid $100,000 to $90,000, up to $90,000, and immediately the gavel went down. Sold. I spoke up and said I would like to bid $10 in real money, pure silver. Sorry, sir, it's already sold. I went over to the man and I showed him my copy of the Negative Averment, which is also an original. And he looked at it and he said, I've already seen that. Kim showed it to me. Kim is the lawyer. Kimberly Rizanka works for Dean Mead, the law firm representing PNC Bank. And I said, oh, and I went back and I sat in my seat. And then during a little bit of a break when the lady was talking to somebody else and not proceeding, I said, sir, what is your name? And he said, Rob. And I said, your last name? And oh, God. Manning. And I said, Robert Manning? And he said, yes. And I wrote it down. He made the bid on behalf of, he said, the plaintiffs. Now, the PNC Bank is not the plaintiff. It's another banker, a retired banker, that initiated the lawsuit, more precisely his wife. But I sat there for a few more cases, and it was like they're calling this an auction. But every time a bid was made, sold. Every time a bid was made, sold. Every time a bid was made, sold. There was no open auction where people were bidding. There was no time allowed for people to actually compete on any bid. It was like a prearranged charade that they knew who was going to buy the house. Usually somebody representing the plaintiff in the action was actually stealing somebody's house. So it's a planned theft of property with no recourse within the system itself. So I got up and I went home. I didn't stay for the entire proceedings. I mean, they had, I don't know, 50, 60 things to call, and I wasn't going to sit through all that. And we were told, she said, now, once this begins, no questions, wait till it's all over. That was, I think, the last instruction before she opened my sale, sold my property. All right. The Affidavit of Negative Averment. I'm going to actually take time, and I'm going to read you at least some of it. I don't know if I'm going to go through the whole thing, but I'm going to read you. Comes now Ronald T. Van Dyke, respondent, by special invitation and not appearing generally, before this court seeking remedy in admiralty, as is provided by the saving to the suitors clause at U.S. Code 28-1333 in parentheses 1. I am standing in my unlimited commercial liability as a secured party and request that the third party intervener do the same and waive all of their immunities. I respectfully request the indulgence of the court, as I am not schooled in law. This is provided by the precedent sent by Haynes versus Kerner at 404 U.S. 519, which is a Supreme Court ruling that actually instructs the judges to help the plaintiff and guide them because they're not schooled. That's the ruling of Haynes versus Kerner. Now, back to the reading. As to count one, I, Ronald T. Van Dyke, respondent, secured party, a natural man created by God, demand that PNC Bank National Association produce their proof of claim. I demand to inspect the original mortgage note with wedding signatures, along with the title page that shows whether or not the mortgage has been satisfied, and at time of signing, I was not provided with full disclosure, which is required by law. I believe that PNC National Association or Harbor City Federal Credit Union or National City Corporation has sold the original note and failed to give credit to my account. This note was created on my credit and signature and was not an asset of PNC Bank Party interveners or PNC National Association or its predecessors shown above. I believe the third-party interveners have not been damaged and have no legal right to a claim. Again, as you know, proof of claim must be established by law. Only the original mortgage note will be accepted as proof of claim. If the third-party interveners have the original mortgage note, let them bring it forth and offer their proof of claim for my inspection. I believe the third-party interveners do not have lawful proof of claim, and there is no evidence to the contrary. According to the clean hands doctrine, this is dishonor in commerce, theft, conspiracy, and racketeering. Opportunity to cure. The third-party defendants have 14 calendar days to cure their dishonor by the following. Dismiss any and all claims against the respondents with prejudice and pay the respondent $2,750,000 as is designated in the counterclaim herein, or pay all damages as indicated by the counterclaim contained herein with real money, surrender any and all public hazard bonds, other bonds, insurance policies, 801k, CAFRA funds, etc., as needed to satisfy the counterclaim herein, or prove your claim against me by providing me with original wet ink documents as required by law through officers of the court in their unlimited commercial liability while under oath, on and for the record, the official record, under penalty of the law, including perjury. This evidence must prove your case by a preponderance or the greater weight of evidence and must answer each and every averment point by point individually. If any and all points are not answered fully and accompanied by lawfully documented evidence as required herein, that will be default on the part of the third party. Non-response according to the conditions herein will be default. Incomplete answers and or lack of documented evidence as outlined herein will be default. If the third party interveners fail to respond as outlined within 14 calendar days, this will be default. Non-response will be a self-executing confession of judgment by all third-party interveners and will be complete agreement with all the statements, terms, and conditions of this contract. This is a contract in admiralty. All non-response will be considered tacit acquiescence. Any response that does not meet the terms of this contract shall be considered a frivolous response. Any officer of the court that interferes or involves him herself with this claim will be added to this claim and become a third-party defendant. Any third-party defendants are collectively and individually liable as a liably for this claim. All responses must be by registered mail. Any other types of responses will be considered frivolous. Counterclaim: the following damages have been assessed against you should you fail to meet the requirements as provided in the opportunity to cure contained herein. Failure to state a claim upon which relief can be granted, $1 million per count per third-party defendant. Failure to respond as outlined herein, $1 million per count per third-party defendant. Default by non-response or incomplete response, $1 million per count per third-party defendant. Dishonor in commerce, $1 million per count per third-party defendant. Racketeering, $1 million per count per third-party defendant. Failure to pay counterclaim in full within 30 calendar days of default as contained herein, $1 million per month and interest of 1.5% per month compounded daily for the first 30 days from the date of default. After 30 days, beginning on the 31st day after the default, the penalties for failures to pay will increase by $100,000 per day for each calendar day that this counterclaim is not paid in full, plus interest. After 90 calendar days of the date of default, the penalties for failure to pay counterclaim will increase by $1 million per calendar day that the counterclaim is not paid in full, plus interest as indicated herein. All claims are stated in U.S. dollars, which means that a U.S. dollar will be defined for the purposes of this counterclaim as a 1 ounce silver coin of 99.999% pure silver, or the equivalent par value as established by law, or the exchange rate is set by the U.S. Mint, whichever is the higher amount for a certified 1 ounce silver coin, U.S. silver dollar, at the time of the first day of default as outlined herein. If the claim is to be paid in Federal Reserve notes will only be accepted at par value as indicated above. Total damages will be assessed as the total amount of the damages as outlined herein times 10 for a total of all damages as outlined in items 1 through 5 added to 10 times the damages for punitive and other additional damages. No judge or officer of the court has any authority to dismiss this negative averment, and I do not and will not give my consent, which is required by law. Signed and notarized. Wow. That's what I served, and that's why I was so jubilant after it had been served. They can't escape out of that, and I will still, even though they have sold my house now, apparently, this is still going to be enforced. Now, here's the thing. Here's the dilemma that we have in matters like this. As I have proceeded in this lawsuit, when I started handling my own case and doing my own research, I submitted numerous claims of right, notices of understanding, and affidavits. Not a single one was ever rebutted or challenged in any way. They ignored them. The process of the court through this whole entire thing has been to ignore everything that I've done. Now, let me say something about UCC 1. Glad I thought of that. This negative averment, you must be a secured party, or don't do it. If you're not a secured party, do not use this negative averment or any negative averment. You first must be a secured party. What is a secured party? It's a person who has filed a UCC-1. Now, in working with the man that helped me prepare this, he asked questions, and I have filed a UCC-1. It's filed at the local level in the court documents. It's filed at the state level with the Secretary of State of Florida, and it's filed at the National Republic Registry on the national and international level. So it's a public record that is available to anyone that wants to look at it. I did not do the birth certificate bonds and all of the other process at the federal level with the IRS and the Federal Reserve and stuff like that. I did not follow through with the United States Treasurer and that part of it, because my thought was, I'm not in this to try to take anything from anybody, not even if it's mine. I'm not in it. I don't want to play that accepted for value game. I don't want to go there. All I'm looking for is protection of me and my property and my rights, which is what the UCC-1 establishes. It establishes me as a free man, as a sovereign under God on the land. And it gives me the rights of the U.S. Constitution and the Bill of Rights and the Florida Constitution and other things. It gives me rights that are given to me by my Creator, but it acknowledges them in admiralty jurisdiction, which is why this is an admiralty document. So again, do not, if you have not filed a UCC-1, do not do this. Now, the man that's telling me, he says the next step I need to take is to do the federal level with the IRS and all of that stuff. That's not the highest right now on my agenda. That's his highest priority for me, but it's not my highest priority for me. And I'm getting lots of advice from people, some of which is okay, some of which isn't. Where I am right now with this, I have friends giving me advice. One friend said, Ron, many of your friends are saying behind your back, I guess he was implying, although that's not what he said, that you brought this all on yourself. Indeed, I'll take responsibility. Just like people have said, Jesus, the story of Jesus in the Bible, he brought it on himself by speaking out and speaking up and pissing off the Sanhedrin, pissing off the religious and the political leaders, although it was the religious leaders that were really pissed off at that time. But I have certainly pissed off my share of people in government, I'm sure. I have made myself a target. I'd rather not be a target. I'd rather just let them leave me alone and shrink into the background. Obviously, that's not what Spirit had in mind, which is why you are listening to this and why you are going to be sharing this with other people. Some of you, not all of you. It's got to go. It's got to go to a bigger scale. The media needs to be involved. Now, I'm being interviewed today, as far as I know, by Bill Martinez from California on his nationally syndicated program. And I don't know if it's a live broadcast or a pre-recording to be shown later. I don't know. I know I was interviewed by a man in Canada 6 weeks ago, it's probably been now, and he was going to let me know when he put it up, and I've never heard back from him. So I don't know if he decided, well, he didn't like the interview, and therefore he didn't do anything about it. I don't know. But anyway, I'm supposed to be interviewed by Bill Martinez. Now, people suggested I should get on Alex Jones. I'm willing to go with any media, newspaper, print media, but especially television or internet media. I'm willing to tell the story and to share what I know about what happened and how the courts are running roughshod, not over me only, but over thousands and tens of thousands and hundreds of thousands and perhaps millions of people in this foreclosure process. Again, understand, in the negative averment that I said, they must produce a wet ink signature note. That is That is the only valid document that can establish their claim. Without that, there can be no lawful claim, period. That is a contract. Now, what they have done here in this case is they have taken paperwork that I did sign, that I was not fully disclosed, and apparently there were some mistakes made according to what I remember other lawyers saying early on in the stage before I knew a lot what was going on about procedures not being properly followed when the paperwork was established. Be that as it may, I was not informed of how mortgages work. I was not informed of many things. And full disclosure at time of signing is required. Otherwise, it makes any contract null and void. Also, the bank never signed it. Only I signed it. And this property that I'm living in was not part of that contract. Now, you cannot alter a contract by common law without the consent of the parties involved in the contract. There can be no unilateral assignment somewhere else. And what they've done is they've attached this property, which never had a mortgage on it, has never been even foreclosed upon as far as in a foreclosure proceeding. And they have attached this to the other document, which the other document is faulty. They've already admitted in the judge's chamber that they lost the original note. That's been admitted, and I've got it in writing that they've lost it, which is why they got the court to allow them to use a robo-signed form from out of the state of Ohio, confirming and utilizing an exact copy. Well, can I use an exact copy of a $100 bill and get it certified? Well, this is an exact copy of a $100 bill. Let me pay my bills with this. That's counterfeiting. And it's just as much counterfeiting when they take a negotiable instrument, such as a note, and copy it and say, well, this is the same as the original. That's not the law, folks. That's not the law. And it's time that we get people involved. Now, it's really important, and I'm asking you, and I know I'm going over on this one today, and that's the way it is. It's important that Jack Parker, the sheriff of Brevard County, be contacted by as many people as possible to uphold his oath of office. I have friends that are in law enforcement. I have friends that are in real estate, and they say they can come and physically, bodily remove me, drag me out of my own home, and take possession of my own home. Well, they can only do that if the police go along with it. But if the police are going to break the law, they must be known that they become party. Jack Parker becomes party to the negative averment. He becomes an officer of the court, operating he's supposed to be in public service. But they're in service, they think they're in service to the people that give the orders. And the people that give the orders are criminals. Criminals with black robes that sit behind big desks and are actually extensions of the banks. You must understand that equity courts are merely extensions of the bank system, which is why they decide in favor of the banks. Not to mention the fact that they get their 801ks, which is their retirement fund, are funded 60% by mortgage-backed securities, which means they have a vested interest in finding on behalf of the banks. They are committing, that's a conflict of interest, and they should recluse themselves. All judges that have an 801k that are funded this way need to recluse themselves from any case involving a mortgage. Period. They are breaking the law. The police, when they enforce orders by these criminal judges, are breaking the law. Now, I've petitioned in my meditation and prayer time this morning the court of heaven, and I've given permission for the court of heaven to become involved in whatever manner is appropriate. And I'm calling on each of you to stand with me in this thing, not for me alone. This is bigger than me, and I want you to understand that. This goes on all over the country in the United States and all over the world, but especially in the United States. And the United States, to me, the United States and Israel are the two most criminal and lawless nations on the planet. On the entire planet. We are the terrorists. We start the wars. We commit atrocities worse than Adolf Hitler, but we have done it over a very spread out and less concentrated thing, and we do it selectively. We don't do it in a big mass like a World War II type of thing. We do it in little skirmishes where we can do genocide to this group and genocide to that group, and wipe out major, millions of people like they've done in Iraq and Afghanistan, and especially in Iraq. We need to take a stand. This is our day. This is our hour. We've awakened. Now we need to let our voices be heard by those in authority. I don't know how this thing is going to come out. Lots of things go through my head. Lots of things come to me, and lots of feelings come up. But I'm amazingly calm considering the circumstances that I'm in. I guess I'm going to leave it there. And I'm asking for those of you that will to get involved at whatever level you can. If all it is prayer, fine. If it's putting me in touch with people in the legal profession that would like to help. Now, as far as hiring an attorney is a person who separates you from your property and keeps you a serf on your own property, keeps you a slave on your own property. In other words, they take power of attorney over you without your even knowing that they're doing it. And when you hire an attorney, you're basically saying, I'm incompetent, represent me. Because I don't know how to represent myself, I don't know who I am. And to some degree, because the law is so convoluted, there is truth in the fact that when you're trying to represent yourself, you're in over your head. There's a cliche, only a fool represents himself. Well, I'm sorry, but only a free man can stand in a free man's power and authority. And he must do that, he or she must do that by him or herself. Nobody can do it for you. But I'm willing to work with people in the legal profession, in the law enforcement, in media, in government, at any level. I'm willing to work with anyone that's willing to work with me to make this thing known, to bring it to a head, to stop this crazy thing that happens when courts and police break the law. So that's the message that I have for today, and it's the longest one that I've done, except for my talks at the New Way. It's the longest one that I've done and put up on YouTube. Again, thank you for listening. Namaste, and I appreciate all your help and all your sharing. Thank you.